can you open a limited company, get into insurmountable debt, close that company down, and reopen a new company, which is essentially the same, under a slightly different name, without the debt? Let's talk about it. Hello, my name's Ryan, I'm the Code Legal Lawyer, and I give a legal view on the latest news. Don't forget to check out our website, codelegal.co.uk. We're offering free consultations for anyone seeking formal legal advice. Now, before we begin, I want to make it very clear I'm not making any insinuations about the conduct of anyone mentioned in this article. We're just referencing it to see how the law works in this situation. So if we turn to the Daily Mail, customers lose thousands as luxury kitchen firm run by Charmer who could sell ice in the Arctic goes bust. Now, we're not going to read the entire article, but we are going to have a look at the key points here. As a family-run business, Parlour Farm Kitchens proudly trumpeted its ability to deliver craftsmanship, quality and sustainability. Its website proclaimed, "We are so bespoke, if you can dream it, we can build it, and if you can't, our designers will hold your hand throughout the whole process." But now, Parlour Farm Kitchens has gone bust, leaving behind debts of more than £2 million. However, it's emerged that even as its clients were being palmed off over delays to their high-spec installations, the boss and his fellow directors were already setting up a new company with a near-identical name, Parlour Farm Kitchens and Cabinet Makers Limited. Okay, if we just skip down, this customer agreed to pay in installments up front, but as installation day drew near, the excuses started. Eventually, she drove to Cirencester and discovered the business was closed. It filed to voluntary wind up 2 months ago. Okay, she was able to get her money back because she paid on a credit card. Others were not so lucky. If we skip down to here, former Parlour Farm Kitchens employees say they were being pushed to make sales as late as November. They now realise the business was struggling and that the new company name had already been registered. Okay, and finally, we knew they were in trouble, everyone did, but they kept on taking these sizable deposits for work on new projects, even when it was obvious there was no way they were going to survive. Now, we have to be aware that company insolvencies are at the highest rate since the 1993 recession, so there is a fair chance that any company you do business with could go under. So to understand the insolvency process, we first have to make the distinction between a limited company and its owners, also known as shareholders. You see, a limited company is a separate legal person, and the owner's liability is limited to what they've invested in that company. So when you contract with that company, any debts or liabilities are held with the company and not the owners. So what an unscrupulous owner may do is they may realise that the company is drowning in debt and that it can't stay afloat, but they keep trading as normal to keep up appearances, even if insolvent. They may be surreptitiously transferring assets at an undervalue or even for free. They may be paying off personal loans owed by the company to individual shareholders, and then they may just strike the company off or let it get struck off by default, so when it's all revealed, there's nothing left in the kitty to pay any creditors. And lo and behold, they reopen a new company with a near identical name and retain the brand, and it just happens to have the same old company assets. There's no doubt that all of these actions and any other attempts to circumvent the satisfaction of legitimate debts owed by an insolvent company is a breach of the strikeout process, and this can trigger director disqualifications, investigations by the insolvency service, personal liability for company debts, and potential criminal penalties in the most serious of cases. What really should happen if a company cannot pay off its debts is that company should enter into a creditor's voluntary liquidation with a licensed insolvency practitioner who will take control of the company and ensure that the creditors are satisfied in the relevant priority with the available assets. So what can you do if you're left in the lurch by a company you suspect has abused the strike-off process? Well, you can report suspected misconduct to the insolvency service. If they've applied to strike off, you can file an objection at company's house. If they've already been struck off, you can apply to have that company restored. You may also consider filing a statutory demand or a money claim at court, as this should also block the strike-off process. So how can we avoid the risk in this situation? Well, you want to conduct as much research as possible into the company and its directors and shareholders. You want to make sure, if they are previous companies, that you're aware of that, and maybe look into reasons and reviews about the companies as well. You want to perhaps avoid paying massive deposits and installments up front without the work being conducted. You may want to see if you could negotiate a personal guarantee from the director. As always, make sure you've got a written contract in any case. Ultimately, you can't guarantee anything, but you want to make sure you've done your due diligence as far as possible. So to answer the question, can a company shut down to avoid its debts and reopen without the debt? Yes, so long as they followed a strict legal process and involved a licensed insolvency practitioner. Otherwise, they're going to fall foul of the strikeout process. So what do we think about this? The insolvency process and companies who strike off to avoid debts. Have any of you got first-hand experience dealing with this? Let me know in the comments. As always, like, share, subscribe. Thanks for watching.